Well, so I have the very challenging but honorable task of trying to make ethics interesting for y'all. I'm going to try to do that for a whole hour. I have some pictures, and hopefully that will make it easier on the eyes. So, Cassie, I'm sure if there's anything that looks wrong with this, you'll let me know, but I think that is working how it should.
It looks
Uh,
good.
Thank you. Okay, so let's start to dig in here. When we, this is about online speech. And so we all know, here's my first fantastic image. We can all worship and honor the Constitution. This is the wrong article, of course, if you're that nitpicky, which some members of the firm are. But this refers, of course, to free speech, which is a basic tenet of law that applies to everybody, including lawyers. Uh, Clearly contemplated within that was that 200 some odd years later, we would have massive tubes of information spreading stuff all over the world. And so what now courts and bar associations across the country are tasked with is how do we balance free speech and public access to information on the one hand with the integrity of the judicial process on the other. And so moving on here, I'm going to kind of go in a circle. I'm going to end with legal advertising, but the bar just published new rules this year that are frankly extraordinary. And the guy here on the right is the reaction of generations of lawyers to these new advertising rules. This is a new comment 5 to RPC 7.1. And what the new 7.1 does is it basically says advertising is okay. So after decades of no advertising, and then we're going to frown on advertising, we're going to put restrictions on advertising. Now the bar, and based on a nationally published study, has taken the position that the public actually needs to have information about what we do and what we've done. It's valuable, especially for people who are not your highly sophisticated repeat players in the justice system, whether it's insurance companies, medical institutions, or what have you. And so this new rule, again, like I said, shifts the importance on to advertising. And it says that must prevail over considerations of tradition. Now, of course, there's the caveat that this does entail the risk of being misleading. And so we'll discuss that later. But I want to start with this so you have this in mind as we go through the sort of for initial factors of trial publicity and case publicity in general. Okay, so I'm going to start here. The materials also start with this, the constitutionality and open courts. This is like bread and butter Washington judicial system stuff. It applies to protective orders. It applies to lots of different things. The public interest in open courts is very strong. And if you've had a Zoom hearing, you notice that most judges will say this is an open courtroom, or the link for this hearing is public information and the public has the right to access it. And the reason is because there's such a strong constitutional interest in having the public access a public proceeding. And so, and that's supported by, I mean, if you have the right to know what's going on in a system that, number one, that you fund, number two, where you can learn if a company is being dangerous, misleading, unfair, somebody who's accused of a crime is potentially dangerous. The public has a right to this information. And so to overcome that right, you have to have not only compelling privacy concerns, you have to have a document log with specific concrete harms, and you have to have narrowly tailored redaction and sealing. The importance of this is that the public record creates what we are ethically allowed to discuss in at least the starting point of what we're ethically allowed to discuss in a public forum like online. Okay, and moving on to the next thing here. The lady on the right is the closest thing I could find to somebody spilling the tea in the newspaper. But basically, if you're broadly disseminating things that are going on in the public record, is that okay? And I'm actually going to start with a non-ethical principle that I think is reflected in the ethics rules and the comments, and that is the fair report privilege. For a long time, newspapers have had the ability to report on what's going on in legal proceedings, even if it turns out the allegation is false. For example, somebody is accused of murder or rape or other crimes like that, that the newspaper can't be sued for defamation for repeating the allegation that the person was a murderer or a rapist. And again, it's an extension of the importance of what's going on in the judicial system to our constitutional process. And so recently, relatively recently, this is the definition of fair report privilege: to accurately report matters in judicial proceedings, even if the underlying content is false and defamatory. Okay, this was recently applied to lawyers and websites for lawyers. And there's the materials reference a case in Virginia, and bars across the country have struggled with this because for a long time, lawyers were expected not to talk about their own cases. And in other words, the newspaper, any old person off the street, anybody with a blog account can talk about what's going on in a public proceeding. But the idea was, or at least the fear was, that lawyers are not able to talk about it. And in Washington now, there's a Division I ruling holding that the privilege applies to lawyers, because after all, who better to explain what legal terms mean with regard to a particular case than the lawyer? Why should everyone else be able to talk about it but the lawyer who was involved? Okay, so fair report privilege does apply to lawyers. And then we come to basically another consideration here in ethics, and that is the confidentiality of information. Okay, so on the one hand, we have public policy law favoring open discussion, open judicial system. The lawyers are allowed to talk about it, and we're going to get to Rule 3.6 here in a minute. On the other hand, we are lawyers who have special rules and considerations that apply uniquely just to us, and they're narrower. So RPC 1.6, just to review sort of the basics, lawyers are prohibited from revealing, quote, information relating to the representation of a client unless the client gives informed consent or the disclosure is impliedly authorized in order to carry out representation. This is the rule where for many years, lawyers thought, and sometimes courts held, that lawyers can't even talk about their own cases, public record or not. You can't talk about it. This is confidential. These rules have been written very broadly. And there is some explanation in the comments about what this refers to, but certainly a fear that you can't even discuss your own cases, in the broader sense of, here's the court record, people can view that in this forum. Is the online atmosphere too much of an extension of the exception to confidentiality? Is it okay for lawyers to go online and publish what's in the court record? And the answer ultimately is going to be yes, but I'll go through some of this here. Comment 21, the phrase information relating to the representation should be interpreted broadly, includes confidences and secrets. Secrets defined as the disclosure would be embarrassing or detrimental to the client. So that's much narrower than the rule would initially seem. And I think it does provide guidance if you're going to publish something broadly that otherwise would be in this tiny little narrow space on the court record, even if it's public court record, especially if it's not of something of serious public concern. And many of us, going to this next slide here, many of us deal with people who come to us in really deeply personal situations, very hard things that they don't necessarily want to be public, and they kind of have to become public in the course of representation. And for example, there's no way to put on a personal injury case without talking about the person's medical history, and that may not be something that the client is comfortable having disseminated broadly if it's something they find embarrassing, like a loss of consortium claim component that they find to be embarrassing. So in certain circumstances, just because your client, something about your client is on the public record, doesn't mean you should disseminate it broadly. In many cases, if you're describing something in a complaint, for example, and it's material that is relevant to the public anyway, that's fair game. But if you're describing something that's deeply personal, something that's likely embarrassing, definitely at least get client permission, preferably in writing, before you publish something like that. Okay, now we get to trial publicity. And this is the sort of counterpoint to 1.6, which talks about confidentiality. And, confidentiality is one of the principal, primary, top level duties of lawyers, right? And that's why so many lawyers were fearful about publishing anything online, sometimes even discussing things privately, but lest publishing anything online. But trial publicity, this rule has evolved also, and it also frankly tends to balance out the 1.6. Okay, because what it does is it basically tracks with the fair report privilege to accurately summarize judicial proceedings. However, just like with confidentiality, and I discuss special narrow rules that apply to us, there are special rules regarding the substance and the timing that are intended to safeguard ongoing proceedings. Okay, and the comments to the rule actually just come out and say this is a delicate balance between the right to fair trial for all the parties and the right to free expression. That includes for lawyers. Okay, and so those are very the rule acknowledges that those are very weighty competing interests and that they need to be balanced together. And so the question is, okay, how is that done? Here's a part of the rule, and the essential component here is, will the speech have a substantial likelihood of materially prejudicing an adjudicated proceeding in the matter? Now, most online content, if for example you just have a blog about a case and it's just been filed, and you're a year or more away from trial, that probably doesn't, in fact I would say almost certainly doesn't have a likelihood of affecting the proceeding, because number one, how likely is it that a juror is going to read your website, and number two, you're a year away from trial. And so maybe special considerations for certain jury pools, but in this context, when a complaint, especially when a complaint is newsworthy anyway, it's something that, for example, when the event happened, the news already covered it, then that frankly should be fair game. And we'll go through sort of the reasons why. There's a non-exhaustive list of exceptions to the rule, keyword being non-exhaustive. That includes information on the public record. Okay, so the public record is fair game. Now, that being said, motions in limine are on the public record. We'll go through why you can't just go and say, oh, we got this terrible rule right in the middle of trial, go on a television show and say, oh, we got this terrible ruling on a motion in limine, this the fact that so-and-so lied 9 times before and yada yada, in 10 years ago, that should have been admissible, that could prejudice the trial. So again, these are things that all come with caveats. Okay. One word of caution on the public record: you can't use the privilege associated with the public record as a way to, or a reason to just slap any old thing you want in the file, right? You can't just file things without a purpose. There's something called a Reinhardt v. Seattle Times protective order, which is a very lengthy opinion, but there's one part of it that describes a protective order where essentially it's just an understanding that you only file things that are reasonably necessary for the litigation. And that standard is a fair one. If there's a reasonable purpose for putting something on the public record, a motion, anything like that, then it's fair game. It's on the public record to a degree. Again, as I said, and we'll talk about that. The rules describe at great length how civil cases are less sensitive to extrajudicial speech. And so that isn't a a blank check, but there's some significant analysis of why criminal cases are more susceptible. I mean, frankly, criminal cases are more sensationalized anyway. The liberty is at stake, so there's that consideration. Trials usually occur or should occur in a shorter window than civil cases, which take a lot of time to develop. So there are other things going on. The one thing that is basically you need to watch out for, regardless of the type of case, is the character and credibility of witnesses and inadmissible information. Okay, so character and credibility, those are frankly fair game, legit public record issues. They're certainly fair game, legit trial issues. However, if you're in trial and you're blowing up something about someone's character and the jury isn't sequestered, that would be a problem. Same thing with inadmissible information. Like with most ethics rules, they're easy to define on sort of the outer edges. There was one case where a lawyer was a prosecutor. I think he was admonished by the bar for publicly during a trial going on a news program and complaining or discussing inadmissible information, things that the court had ruled was not going to be admissible. Again, that's kind of the extreme example. What about 3 months before trial, 6 months before trial? A lot of it depends. Okay, and so here are some of the recommendations that I've come up with here. The complaint, number one, is probably fair game, and that's in part because, you know, almost no matter where you file in this state, you're months and months and months away from ever being able to get the case to trial, get the jury for the trial. You should, especially in again an online environment, avoid comments about a party or witness's integrity, again, unless it's directly from the proceedings, and even then you may want to have other considerations. Those are again identified in particular by the comments as having a likelihood of affecting the trial. Avoid publishing material you should know is inadmissible. Again, how you're supposed to know that a judge might rule on motions in limine? You can't, but if you suspect there is going to be a motion, then at least there's something to evaluate and to do your due diligence on. Near trial, I would recommend taking web content down. What does near trial mean? I would say 30 days. I think it kind of depends on the case. It depends on the venue. I mean, it depends on a lot of different things, but certainly within 30 days, I would recommend taking web content down. Another thing about avoiding certain types of material online is don't add commentary. Okay, so if you have a complaint that you're really proud of, you post it online, okay, that's part of your publication, it's already on the public record. You can explain what some of the legal terminology means, because even seasoned reporters sometimes, they don't like, why didn't you put a damages amount in your complaint? Well, we can't do that. You know, they'll ask you, what does this cause of action for, you know, Consumer Protection Act mean here? You can explain in everyday language what the complaint and the terminology refers to. Don't add commentary, because that is probably outside the protection of the fair report privilege. And it may also be, and likely is, outside the protection of these rules, depending on the extent of it. Not, you know, if it's just trying an effort to explain what's going on, then that's different. But if you go into commentary that is accusatory and detailed, that could pose a problem. Okay. There is one more exception worth mentioning, and it may or may not apply in plaintiff's cases, but certainly in some contexts, you know, in defense cases, is the exception for defending a client to the press. That basically, if some accusation has been leveled against your client, plaintiff or defendant, civil or criminal, then you have the right to rebut that in a public setting. Okay, and that I'm not covering that in detail, but you can certainly consult the rule on that. By the way, you feel free to type questions in the question and answer thing, and I'm happy to get to those as we go. This is going a lot faster than I thought. I'm going to circle back now to faithful communications regarding a lawyer's services, a fancy way of saying false advertising. Starting here, 7.1, material misrepresentation of fact or law. The guiding light in any consideration, well, first of all, let me start back a little bit. A lot of the speech that we're talking about and discussing our cases is of societal, we view it as having societal importance and is not necessarily just commercial speech. But many courts will look at us, blogging on our personal sites, our websites, whatever it might be, and say, there's a contact me page here, that's commercial speech. And there are certain different standards and rules that apply to commercial speech as opposed to political speech, which is sacrosanct and almost untouchable. So most of what we're talking about is commercial speech. The guiding light here for communications regarding our services is what is the reasonable expectation of a prospective client. So when this rule discusses a material misrepresentation of fact or law, that usually comes up in the context of one of two things: an unsubstantiated assertion that does not convey meaningful information, and unsubstantiated comparisons to other lawyers. Okay, so the outside edges of this rule are kind of obvious. You can't say, I'm the best lawyer in the state, neener, neener. Okay, you can't say, I always win. Okay, we all know that. And in the materials, I mentioned advisory opinion 2206, there's an example of, quote, attorneys who get results, end quote. Without explaining what that means, without disclaimers, that's problematic. It's vague, and it could very well be misleading. Now, okay, this all being said, it doesn't mean you can't use adjectives to describe yourself or your firm. Okay, the important questions are, number one is, can you prove it to a reasonable degree? What is underneath the assertion that you're making? Okay, do you have context that supports it? And number two, is it misleading? In other words, is it technically true, but gives the wrong impression? And the classic example of that, at least in my view, is when lawyers have quote unquote certifications or awards that make it seem like they have something akin to like a board certification for doctors. And I'll discuss this a little bit more when we talk about specialization, but that's the kind of thing that can be problematic. And it's why, when we talk about, well, awards, we usually use careful language for, what that means. It's an award or a title bestowed by a magazine or publication. And so you just have to be careful that you're explaining what it means so that clients don't think that you have some kind of the equivalent of a board certification in class actions, for example, something like that. So moving on to this next, here's the rule again: omits a fact necessary to make the statement considered as a whole, not materially misleading. So the biggest issue that this usually comes up in is, how are we reporting results? Okay, so we all like to have, like, I did this cool thing and that cool thing, whatever your thing is, right? Like musicians, plumbers. I mean, everybody wants to, like, we've done this great job on this architecture and that. We all want to talk about what we do. We enjoy it. We want clients to be informed about what it is we do. The problem is clients don't really understand the civil justice system very well. And in fact, they may have perceptions that will lead them to erroneous conclusions. It's human nature to think that good prior results will lead to good future results, right? And that's kind of what we're trying to show is like, we have experience and we've done this successfully before. We can do this successfully for you. Okay, we can take good care of you. That's what any business is trying to convey. But for example, so clients will sometimes, and we've all had communications with people like this, they think there's some standardized method for calculating damages. And so, if this happened to me, and this happened to this other person too, and their case was worth $1 million, why is my case not worth $1 million? That, albeit is annoying to us sometimes, it's a very understandable perception from clients who just don't know how our justice system works. I think most people are shocked when they find out that the jury instruction on general damages actually says there's no method of calculating this. You have to just use your common sense and figure it out. Paraphrasing, but that's essentially what it says. And so that needs to be conveyed, ideally person to person if you're actually in touch with a client, but on your website as well. As you all know, we also don't have punitive damages in Washington. And so, but most people don't know that. It's something they've heard before. They hear about large verdicts. Almost every state in the country has punitive damages except us. And so these kinds of things don't necessarily, you don't need to have a dissertation on it on your website, but you do need to have something that triggers the knowledge that things are different. Okay, cases are unique, circumstances are different. The adversarial process itself generates uncertainties and differences between cases. So you need to kind of dispel that. And the best way and the recommended way by the bar, and I would second that, is to use a disclaimer. The comments specifically reference appropriate disclaimer or qualifying language. And again, it's important here that it's referring to unjustified expectations. You don't have to cater to unreasonable expectations of people, but if a reasonable person, that language does come up in these rules. Okay, so if a reasonable person would interpret your website to mean something that it doesn't, or that isn't provable or accurate, reasonably provable, then that's a problem, and you would need to fix that. Okay, what essentially is recommended in these advisory opinions is something along these lines, which we've adopted. Like every person, each case is unique. Prior case results should not create expectations of an outcome in any individual case. Again, we're not going to explain the entire civil justice system in a disclaimer. We explain a lot on our website in the form of blogs and practice area descriptions. So there is more context to it than that. But the key here is that there are unique differences between cases, and that one outcome in this case doesn't necessarily mean the similar outcome in even a case with a similar injury necessarily. And so it needs to at least trigger a question in the audience that they need to have that conversation with you before just assuming that what your website says is that, my case is most like that one right there, so it's worth this much money. That's the kind of thing that you need to disclaim. Okay. Here, where did it go? Okay. So I actually just found this out. I knew it was in the works, and I just found this out. The bar has finally done away with, again, based on a national study, the prohibition on specialization. And what I think is sort of behind this, the rule, as I have always understood it, is that you don't want to, specialties and specialization gives the impression that we are like surgeons and that we have board certifications for fill in the blank type of surgery or work that we do, when in fact that's just not true. I mean, there are some certifications for some practice areas. There are certainly awards that are given out, but there are not specialties in the same sense that there are in medical fields. However, now that everybody is shopping for everything online and can compare and contrast services very easily, I think that the bar has rightly concluded in the Supreme Court in adopting these rules, that is no longer a term that conveys the meaning of a board certification. We in fact do specialize in certain areas of law. Gone are the days where, at least for most of us, it would be the norm to be a jack of all trades, a general practitioner. Most of us, quote unquote, specialize or focus almost exclusively in one or two things. And so it is accurate and not misleading to say that you specialize in certain things. The same way that, a plumber might specialize in renovation as opposed to original construction. And you could say the same thing about certain accounting work, and different, every type of profession there is, you could say they specialize in something. And consumers kind of know that now. And so the caveat here is, of course, that you can't use it in a way that is misleading. But as of January of this year, you can say that you're a specialist. I would say saying you specialize is a little bit safer than saying you are a specialist, which implies a little that you've been sort of granted that label somehow. But you can use this language now as long as you're not being misleading. By the way, there is a link in the materials to the lengthy national study that these new rules were based on. And I think it's very enlightening to see where bar associations and Supreme Courts of states are going with this. It is much more in the direction of understanding that this whole internet thing is not slowing down, and the sort of the rulemaking process, the case law process cannot keep up with it. And so when we're talking about trial publicity, in some respects, but certainly with advertising online, you can expect to see that what is reasonable expectation of a consumer, what is interesting and important and helpful, is going to change more rapidly than courts really can keep up with. That being said, don't be misleading. So, okay, and just to clarify on this, 7.4, which was the no specialization, has been repealed. This is a comment 8 from new comment under 7.1. Everything's been sort of shoved into that rule and added in the comments. So there's more new rules on advertising. Okay, so there's an additional comment section under 7.1. And not only did they repeal the strict advertising rules, as I mentioned before, they went fully in the other direction. We're saying, tradition over here, fine, we acknowledge that, but people have a right to know what they're buying when it comes to legal services. And we don't want to give the impression that lawyers cannot explain what it is they do, because that's valuable information. Client reviews, case descriptions, even outcomes, as long as they're not misleading, are valuable sources of information for people trying to find legal services. Okay, going through these rules a little bit here. Here's comment 7, and I found this. I'm just geeking out here, but I found this really interesting because first of all, it's a broad acknowledgement that the old way is out. Questions of effectiveness and taste in advertising are matters of speculation and subjective judgment. And so for so long, whether it's allowed or not, it was frowned upon in many circles to do even online advertising, much less on a bus advertising or on TV or on radio advertising. The bar has decided to try to end that debate, okay, and accept that is a valuable resource of information if it's done without being misleading. And it calls out specifically persons of low and moderate income, not your big corporations and insurance companies who are repeat players, have the inside track on information. Not only that, they have bargaining power in terms of who they hire as a lawyer. A tenant facing eviction doesn't have bargaining power, doesn't have necessarily the ability to interview 10 lawyers and see which one best fits what they need. They need to get that information online. And so the critical part of this is at the end, where it says that that the old way would assume that the bar can accurately forecast the kind of information that the public not just would find helpful, but would even be relevant. Okay, so this is what I was alluding to earlier. The bar is acknowledging that, oops, that this has gone, that the amount of information out there is such that, and that public perception is changing so rapidly because there's so much information out there, that the bar can't even be in a governing position to predict what the public will find useful. Therefore, we're stepping out of it. And as long as you're not being misleading, then it's fair game, with the caveat of what we discussed before about confidentiality and trial publicity, of course. So I found that to be a huge acknowledgement that things are simply moving too quickly for the bar to be able to govern this by rule, and or even by case law, which is kind of how most of us are used to things being governed. Specialization actually is a good example of this, because the premise of the old rule doesn't apply. People go online and they can tell the difference. They can compare easily. Somebody who says they're a specialist here and a specialist there, which is a better fit? It's much, much easier when you have access to that information. Okay, so I'm not sure how this is necessarily going to work in a in the webinar setting. Maybe Cassie can help me out. But one of the things that I've always seen at ethics CLEs put on by the Bar Association is hypotheticals. And so I've got some hypotheticals, and I'd love to see what you guys think about these. Please feel free to put questions and answers in either the question answer thing, or I guess I would be the one putting the answers in, but in that you can also use the chat window. And also, we can just give people the mic if, Cassie, if you're able to do that as we go through here. Okay, hypothetical one. You represent a personal injury plaintiff in a claim against XYZ Corp. You sent a demand letter, didn't do anything. Now you just filed the complaint. Prior to filing, the client looked at it and reviewed. The complaint specifically references injuries, which include incontinence. You get a call from Mr. Nosy at the small town newspaper. Mr. Nosy wants to know if the injuries are actually serious or if this is just another, quote, frivolous lawsuit, but he can't get down to the courthouse. Can you give him the complaint? Can you discuss the injuries with him? Should you? So this hypothetical addresses not just your own online speech, but other people who are going to be posting articles on the internet. So I'm really curious what, based on the rules that we've already discussed, you guys think, and I'm hoping I'm not going to just be talking to myself here. So y'all, please do speak up.
If they click the raise the hand button, I can unmute you guys. Oh, here we go.
Pat here, can you hear me?
Yes.
Okay. I would ask the client before I did anything like that at all.
Why is that?
Well, then I've had a few cases like you guys that have drawn the attention of the press. It's one thing to have a statement of incontinence in a public record, such as a complaint. It's quite another for a newspaper person to comment on it. I guess I'd go back to how the complaint was drafted and say, you know, serious personal injuries as opposed to the specifics, even though the client has approved it. The other thing I would probably do is set up depending on who the client is, set up an interview with the client and the member of the press, and let that member of the press get to know the person who's hurt. I find that has been helpful in getting, you know, Mr. Nosy, who thinks that this is frivolous, when they actually get to see the person who's injured, you can often flip the story that they're going to write to one from this is a frivolous lawsuit to one, this is a really nice person who's genuinely been hurt.
That's a really good point. And actually, I'm glad you brought that up, because one of the big philosophies that we have is basically, you know, the complaint itself is often newsworthy. And coming with that, with a human angle to avoid these misperceptions that are out there can be really valuable to your client, both internally and in terms of their case externally. So I think that's a great idea. Have your client speak up for themselves, humanize it. Absolutely. Let's see. I see Seth Rosenberg wrote, you can provide the complaint, but I would not discuss the injuries. Seth, did you want to talk on the mic, or do you want me to just respond? Cassie, can you give him a...
Oh, hi, Andrew.
Hey.
Well, the complaint is a matter of public record at that point.
Correct.
So you're not providing anything confidential. But obviously, this early on in the case, I wouldn't want to be discussing anything about the details of the claim that aren't in the complaint.
Yep. Certainly. And well, and what if the fact of incontinence was in the complaint? What about then? What would you do?
Well, I think I would just provide them the complaint and say that at this point that, the matter speaks for itself. But I'd be hesitant to try to detail aspects of damages through the press, other than to say, and we've had cases like this that have gotten in the paper, and we simply, sometimes we make the plaintiff available for interview, but those are pretty carefully controlled situations. Pretty much we'll provide the complaint if people ask, because again, it's a matter of public record. He just can't be bothered to get down to the courthouse.
Yeah, I think, I would caution that there are some, I agree with what you guys have said, by the way. I would caution there are some opinions out there that that you cannot disseminate a complaint even more broadly than what is on the record. I think that Washington law, based on everything that I've reviewed and presented, would agree with sort of where we're at on this, which is that, unless your client has a wish that is different from dissemination, that providing it so that the reporter can have accurate information, because sometimes, like I mentioned earlier, reporters don't even understand the legal claims, and providing the complaint is the most accurate way to give information of what's going on, so they don't mess it up, right? And that way also you can refer to that and be protected by the fact that you're just referring to something that is on the public record. It looks like Mr. Adler would like to speak. Please, Cassie, give him the mic.
Can you hear me?
Yes.
The answers to some of the hypotheticals was already given, so I am now muted.
You're well,
I am muted, and I should be muted.
okay. All right. Anyone else before we move on? I do have other hypotheticals. I think those are really, really valuable points. Okay. Hypothetical number 2. You represent a person insured under a homeowner's policy by American Farm. American Farm is denied coverage, claiming that your client committed fraud in the application process by stating he had wired smoke detectors when they were battery operated. You sued the insurance company alleging bad faith, negligent misrepresentation, and fraud. It is 2 months before trial. American Farm files a motion for summary judgment alleging fraud by your client, and the local small town newspaper picks up the story. The paper wants your comment. You have not yet filed your response brief. What can you tell them? I see 2 hands raised. Let's give, I should have my, Cassie, go ahead and go one by one, whoever wants to answer this one.
So Kat here, I've done a huge number of fraud cases in real estate. They arise. I think what I would talk about here would be the standard that American Farm has to meet on the claim that they've brought, which is clear, cogent, and convincing evidence under fraud. And that is really a tall, as I call it, a 90-degree glass wall you got to climb. It's really, really tough. I don't think you can say, well, here's how we're going to defend this thing because you haven't actually filed it.
Okay.
Yeah, I think it's how hard such a claim is to prove is where I go.
Okay. So that's a great idea, and it's kind of cautious, but I think that's definitely a good thing to focus on. Let's see. It looks like Mr. Adler is here, ready to talk as well. I just figured out how to unmute you guys, I think. No, I can't. Cassie, can you unmute Richard? Where'd he go?
Right here.
Oh, okay, good.
Well, I would refer them over to you, Andrew.
Oh, okay. Here's what I would say. This does fall under the exception for defending your client based on an accusation. And so I think you could, almost anything is fair game here. For example, most defendants, when you file the complaint and they're asked for comment, they won't say much, but they can. They can certainly dispute what's going on. And I think in this case, addressing something that has been made public and you're being asked about it, I think is fair game. But certainly what Kat mentioned about limiting it to the burden of proof and simply disputing the claim is a good way to go too. I think, if it were 2 months before trial and somebody did this to my client, I would fight like crazy. But that doesn't mean fight in the press necessarily. I think you can spell out what your defense is in some detail under RPC 3.6. All right, let's go to, this is actually going to be my favorite one. So, all right. You guys, I just had too much fun with some of these. Okay, The Arguers, a local personal injury firm, has a heading on its website for, quote, representative cases. That webpage includes a list of large verdicts and settlements, starting with the largest on top and going down to the smallest one listed of $250,000. The dollar amounts are bolded in large font. In the footer of the page below the firm contact information, there is a disclaimer that we do not guarantee case results. The main page of the Arguers website prominently features the slogan, "We recover while you get better." Below the slogan, the headline reads, "Certified Best Personal Injury Firm in Washington." A footnote follows, citing to the National Institute of Self-Aggrandizing Lawyers of America, aka NISLA, which offered the award to the Arguers, and the law firm accepted the award by paying $300. What potential ethics issues do you spot in this scenario? There's a lot, and some of them are actually debatable. So who wants to go first? Cassie, can you give the mic? I see Justin raising his hand.
Yeah, well, aside from particularly calling out my website, Andrew, no, I mean, self-aggrandizement, you're not certified best anything unless the certifying organization is under ABA pursuant to the rule. I think that's the main red flag issue here.
Thank you. Who else? Richard again.
Without addressing the question here, I have a broader question, more of a 360.
Sure.
When I look around recently into what's going on in social media, I'm very concerned by some of these kind of representations that are embedded in your hypothetical. And I'm wondering, does the Bar Association actually look at this kind of stuff and do something about it? Because it seems like it's gone from modestly bad into really hyperbole in terms of what's being used out there. And it seems like is the responsibility on WSAJ to self-police its members? Is the responsibility of the WSBA to police its members? Is it the responsibility of individual attorneys to report it? And what's your, give me a broad scope on how do you enforce bad conduct to make, and where's the accountability and who's responsible for that?
Yeah, what's a really good question. I don't speak for any of those organizations. Obviously, I can give you my opinion.
Sure.
First of all, I think, you know, it would put WSAJ in an awkward position if they had to do that. And so many of these are nuanced that I don't think that would be a fair expectation. It's the bar. The question is, how does the bar get aware of this information and what do they do about it? I think obviously, well, I would be surprised if they police it themselves. First of all, they don't follow, I would imagine they don't follow every law firm on Facebook, for example. I think it's reliant on lawyers reporting it. And in most cases, I think the bar will just ask people to clarify their language or take it down. But you're right. I mean, this, you know, it's a legitimate question as to whether, and you know, when you pay for an award, in other words, not just the plaque associated with it or the magazine entry, but you actually pay to have somebody award you with something. Is that okay? Is that misleading, even under the new rules? And that's what I think one of the things that I'd really like to talk about a little bit more. Kat, I see you have your hand raised again.
Right, that's what I was going to say, is that paying somebody to get an award is ethically problematic, as I understand the rule. If someone wishes to give you an award, you shouldn't have to write a check for it. So, you know, things like super lawyers, for example, you don't have to pay to get on it, although they like it if you know, buy some of their stuff. AVO, to me, is problematic in that they seem to want money, and I don't play with AVO particularly because I think it violates this rule. Others may have different opinions about that, but it's not an award if you have to pay for it. Isn't that kind of the rule?
Common sense would dictate, as they say. AVO or AVO, however it's pronounced, I've never paid for any you know, like to have stars ratings or anything like that. I'm not aware of that kind of thing with AVO. I mean, certainly you can buy ad placement and other things. I'm not really totally familiar with it. But just as far as the rating and the client reviews, I mean, that's as I understand it, is an algorithm that they use. But anyway, I see Justin's raised his hand again. Go ahead.
That might have been an error as I was doing some keystrokes while working on a document. My apologies.
All right, no problem. Shannon. Oh, now her hand went away. No,
I'm here.
You're here. Go ahead.
I was just going to say, I don't think the disclaimer, "we do not guarantee case results," is good enough, given what they've put on their website in terms of case results. I don't think there's enough context there.
Agree. Why not?
Well, because it doesn't do anything to explain why case results might be different.
Excellent. Totally agree with you. Yeah. I mean, it is true that lawyers can't guarantee case results, but does that do enough to explain or dispel the heading, quote unquote, representative cases? I really hate that heading because it does suggest that those cases are representative outcomes. And of course, that we all know that this is way too complex to say that outcomes are representative, unless something's been litigated 100 times before, like asbestos, and there's just almost a formula to it. There aren't any real representative cases, in my opinion. Plus, if you're going to claim things are representative cases, you're going to include the $5,000 settlements and the $10,000 and the $15,000 settlements, because if you need to have a representative sample, right? So under that heading, yeah, absolutely. We do not guarantee case results does not do enough to undo the representations near the top. What else? Who else wants to discuss? What about let's see. We recover while you get better. What do you guys think about that? All right, well, I'll tell you what I think about it. You know, there are firms that say that. I think in and of itself, maybe not so bad. The problem is, number one, you don't recover the money while they get better. That's just not accurate in most cases, right? So you recover either after they've gotten better or after they're, you know, a year into getting better. And I think in the context of everything else, it presents a misleading impression that they can sign up with you and somehow you can just generate cash starting to flow in. The other thing is, we all have had an experience where clients will confuse first party coverage and, for example, their UIM, which is first party coverage, but you have to prove it. And they'll confuse it with the third party coverage, which isn't going to pay as you go, right? So saying we recover while you get better it suggests that the other party's insurance company is just going to start shelling out your medical bills, and we all know that that's not true. So I think that's kind of more granular, drilling down into the actual experience of it, but it presents the wrong impression. Kat's hand is raised. Go ahead, Kat.
Yeah, and I was going to say that this is a really clever marketing statement, and our marketing person here is grinning. And I think what this statement brings is the clash between what flies for other industries and doesn't fly for lawyers. You all have met Mark, my significant other. He's an engineer, and he goes, "Why don't you do X?" And I said, "Well, I can't do that because the rules say I can't." And it just baffles his mind that I've got a whole pile of rules that don't make any sense to him. Right. So this we recover while you get better. I could see a marketing person saying that's great, that's catchy. People are going to remember that. That's going to just drive all kinds of people to your office. And I, as you've probably figured out with me, I'm a little more conservative on all of this stuff. That's almost a guarantee of an outcome. And I think it's problematic under the rule.
Yes, that's actually a great point. And it was so obvious I overlooked it. It does guarantee an outcome. It suggests that you for sure will get a recovery, which we all know that's not the case. There could be causation issues or liability issues. So it's problematic right at the top. So it is 1 o'clock. Thank you everybody for attending and your participation, especially those of you who spoke up. Cassie asked y'all to put your names and I think it was bar numbers in to make sure that we give the credit. Cassie, you can go ahead and take over and tell everybody what you need.